Hello, everybody. This is Jonathan. I hope you guys are all doing very, very well this Thanksgiving week. I am not in my home office, as you probably can tell. This is a fake background, but it's better than just seeing this is an empty bedroom. Families in South Carolina. We decided to take a little break over the Thanksgiving holiday. So again, I don't know how technically how well this is going to work, but we will find out. So hopefully you're hearing me okay. And again, we will do the best we can with a wireless connection. So again, I hope everybody's doing well. And just in the spirit of Thanksgiving, I'm very thankful for everybody here, everybody that spends their Wednesday with me. It's much, much appreciated. This is something I enjoy doing, but I really enjoy the feedback I get from everybody, the great questions and the really positive reviews that I've gotten over the number of months I've done this. So thank you very much. And I hope, again, to all of you and your families, I hope you have a really, really great Thanksgiving. All right. So Christina is one of my regulars. And so she says, hello. Hello, Christina. I hope you're doing well. And she reminds everybody to please like, comment, and subscribe. That is much appreciated. Thank you very much. I hope that you all will. All right. Teresa, I believe Teresa has been here before. She says, has a question. Does it mean anything when you have an appointed representative notated in your SSA account? Are they getting close to a decision? It does not mean anything regarding the speed or the process. All that means is that you have an attorney or a non-attorney rep who's been associated with your file, and Social Security has put that into the system. Social Security, in order for an attorney like me to get involved in the case to assume representation, I have to submit a form called the Form 1696. And this is an appointment of representative form. I would also file a fee agreement, which is Form 1693. And the 1696 and the 1693 have to be signed by me as well as my client. So sometimes it takes them a little longer than it should to associate a rep with the file. And so that's possibly what's going on here, but it just means that the rep has been associated. That's pretty much all that means. All right, Teresa has a second question. Could you please explain the trial work period? Happy to do so. And let me get the numbers here so we're talking real numbers. Give me 1 second here. Well, I'll just tell you big picture. Trial work period is a program that Social Security has that will encourages you to try to work after your onset date. Some people get confused. It's not after the date you're approved. It's as of the onset date. So theoretically, you can start using your trial work period months as of the date of onset, which would be typically, right after you've applied. I mean, your onset date could be up to a year prior to, you get paid up to a year prior to application. So you can use, so let's say you claim that you became disabled in February of 2023, and you start working in March of 23. That can be one of your trial work period months. Now, again, you have to get past the question by a judge of whether you were able to work. But if you were working your trial work period months and you didn't do it consistently, a judge would not penalize you for that, if that makes any sense. So in other words, as of your onset date, whenever that may be, you have available to you 9 trial work period months. And the trial work period table, I'm going to put that in the the comments here. Give me 1 second there. Let's put that in the comments. Okay. And basically what it says is for 2024, if you go to work, if your onset date is in 2024 and you earn in a calendar month, and this is when you actually get paid, not the month you did the work, but the month you got paid. So if you worked in February, got paid March, that would count towards March. You can have $1,110, 1110 of gross earnings. That would count as one of your trial work period months. In 2025, it's going to be $1,160. So starting in January, if you work, you can earn up to $1,160, and that will not count as one of your trial work period. You earn $1,160 or $1,161 or more, you use up one of your trial work period months. you have 9 of these trial work period months in any 5-year period of time. And if you, let's say you're approved and you work and use up 2 of your months, in 2023, 2 in 2024, 2 in 2025, will not affect your benefits. So if you, during the trial work period months, if you're below the figure, again, in 2024, 1,110, you earn $1,000, doesn't use up a trial work period months, that's considered not substantial gainful activity. It's not trial work period. You can do that indefinitely. If you earn $1,111 in 2024, you're using up one of your 9 months. You could earn $10,000 a month. It doesn't matter. You're still using up only 1 month. And generally speaking, trial work period months, are not going to trigger a continuing disability review because Social Security wants you to try to work. So again, you're trying to work, you're earning whatever you can earn, $2,000, $3,000, $5,000 a month. You have up to 9 of those months. Once you hit 9 months and you've used all your trial work period months, you still don't lose your benefits unless you start going over SGA, which is another set of numbers. Again, in 2024, it's $1,550. I think in 25, it's $1,620, I believe. But bottom line is that if you use up your trial work period months, but you stay below SGA, you're not going to have a problem. Now, that could be something that they use to look at it for continuing review because you're now starting to work on a continuous basis. If you go over SGA, again, you've used up your trial work period months, you start going over SGA, that puts you in overpayment status. If you over SGA for 1 month and then under for the next month, you would be over that. You'd owe them back that 1 month. And again, at some point, they're going to move to terminate you. But a couple of months here and there are probably not going to do it. But it's not nice to get that letter that says, by the way, you owe us, $5,000 or whatever. One of the big practical issues is that many people, this is going beyond Teresa's question, many people, when they start using up their SGA, they're over SGA, Social Security doesn't tell them about it for 3 or 4 years. So somebody may not realize they're over SGA and they're continuously over SGA for month after month after month. And then 3 years after they were approved, they get a letter from Social Security saying, excuse me, you owe us $50,000. Here's an envelope. So you're going to be really, really careful about keeping track of your trial work period months as well as your gross earnings. Are you over SGA? Unfortunately, there's no real-time reporting of this. So you can't go online to see, have you gone over? You got to keep your own spreadsheet, which is, again, something I think they need to really fix because it's very easy. If you think about it, given that there's a 5-year window, again, it's rolling. So, if you use 5 years, 60 months, once you get beyond that, month 1 rolls off and you have another 5 years that goes on. It's rolling. So, you don't use up your trial work period months. If, let's say, you used one up in March of 2025 and then 2030 rolls around, April of 2030, that March of 25 rolls off. So it's, again, kind of a rolling thing. It can get very confusing, very easy to get over an overpay status because, again, trial work period months is no real-time reporting. It is going to be something that, you have to keep track of. And if you're two months in 1 year, 2 months in the next year, 2 months in the next year, all of a sudden you may hit that 9 months and not even realize it. And there's no way that you're going to know unless you keep track of it. And again, gross earnings, in the month you receive it. And there are some reductions for expenses that you might have to incur to allow you to work, or business expenses, things like that if you're self-employed. But you want to be really, really careful and keep real track of it, because having been in litigation over this in hearings, you have to literally come to court with a month-by-month breakdown of all the earnings you had, in the months they say you were overpaid. So you want to be very careful about that. So I hope that explained it. I do have a couple of videos about this. If you just go to trial work period under Social Security, you'll see some other websites, Social Security's website, that explain it as well. But bottom line is, it's a way for Social Security to encourage people to go back to work. They put the burden on you to keep track of it, and the figures, are this not the same as SGA. It's lower than SGA, which doesn't make a lot of sense to me, but that's what they do. So you need to look at that table I put in the comments and just really keep track of that. All right, cancer-free, 58 years old on 4 liters of oxygen continuously. Social Security by medical stuff for 3 months. Any suggestions? Okay, you are probably a listing level case. If you're on oxygen, I believe that would make you listing level. And let's see if we can find the listing. I'll tell you what I would do. Let's see here. I'm on, like I said, a wire. If you can still hear me or not. Okay, there we go. I think when I was trying to go to another website, it froze me there. So I'm not going to do that anymore. But let's take a look. Look at listing 3 under respiratory system, and you'll see a number of different listings. I suspect that 3.02 might apply. And so anyway, I think you made a listing. So what I would do is, number one, I would print out the listing, listing 3, take it to your pulmonologist, ask your doctor, will you write a letter stating that I meet or equal this listing? Then I would submit that to the adjudicator. If you're not getting anywhere, it's been 3 months, they've been working on it. This might be a situation where you reach out to your United States senator and say, look, I have a listing level case. I'm really suffering. Will you please contact Social Security on my behalf? That is called a congressional inquiry. Congressional inquiries get your case moved to the front of the list. So, that is the deal. Now, you have an attorney. It is the process. And again, I think that what I tell my clients, is you really got to contact your representatives. Given the delays, and again, I've used these numbers before. In general, initial application 8 to 12 months. So if you applied 3 months ago, that's probably a little too early to reach out to your senator. You applied 5 or 6 months ago, it's okay to do so, I think. And yeah, it is part of the system, but that doesn't mean you can't be a squeaky wheel. And I think that's what you should do. If you're on oxygen, you do have a listing level case, I believe, and I think that would be something that really you ought to really do. And your attorney should, again, your attorney can't do it for you, but I think it is something that would be helpful in getting your case moved along. Is going to the congressional inquiry route here. Okay. I-43 Reyes. My husband was told by his caseworker this case was adjudicated. What does that mean? That's normally you don't see that phrase. Basically, an adjudicator is the representative or the claims manager for Social Security, the person who's doing the evaluation. When they say adjudicated, that means something has been decided. So I'm assuming that they have made a decision. There are 2 parts to the decision. There is the medical part, where they decide whether you meet the standard of not being able to engage in substantial gainful activity because of a documented medical condition. That is the medical side of it. The non-medical side of it would be, in an SSI case, do you have assets and earnings or household income that would eliminate your eligibility? Or in an SSDI case, are there earnings from work after onset? So there's 2 parts to it. So typically the medical part is done first, then the non-medical part is done second. So I think this just means that you're getting close to a decision, hopefully a favorable one. Trish says, hope you have a great Thanksgiving. I hope so too. Again, we're, we rented a house, my wife, my daughter, son-in-law, little baby granddaughter. Son couldn't come this time. He had too much work to do, but we got a big turkey. So my wife's going to be making the turkey tomorrow. So hopefully it'll be good. Calvin says, good evening. Johnny says, good evening. Good evening, Johnny. Let's see. Cindy says, for SSDI, my last 5 years, I was in the PHL, I'm not sure what that is, working 4 years for foreign tax, maybe Philippines, I'm guessing foreign tax exclusion, so I didn't have to pay disability insurance. Do I still get credits? I don't know. I don't know that you would if you're not paying, because typically most of the countries that have an exchange with Social Security have their own Social Security system. That would be something where the first thing I would do is get your My Social Security Statement, ssa.gov/my account. That's the first thing I would do. The second thing I would do is perhaps call Social Security and ask them, ask them, do I have enough credits for disability? I think if your statement would tell you that, but I honestly don't know. But I think that could be an issue. Could be an issue if you were not paying into the U.S. system. Fowd says, I appealed for the appeals council, made a mistake. I didn't hire a lawyer. Do you approve at this level to get back pay? So it's disabled since February of 21. Well, the appeals council is the first post-hearing appeal. They're going to be looking for an error of analysis by the judge. My experience has been the appeals council is kind of a rubber stamp. The next step is federal district court. You definitely need to get an attorney for that. There are a number of attorneys out there. If you email me, I will give you a couple of names of people that do federal district court work, and they will tell you whether they think you have a federal district court case that is viable. But the appeals council, you really should have an attorney for that. But if you didn't and you're denied, the next level is the federal district court. Again, you got to file an appeal within 60 days, though. Okay. LinkedIn user, I like to paint and decorate. I'm just admiring that beautiful living room. It is not. This is a fake background. I'm sorry. This is not real. The background here is there's two like double beds here and a bunch of stuff. We had to move a bunch of furniture in here because I have a 14-month-old granddaughter, and of course she's grabbing everything. So all the stuff that was dangerous was stuck in here. So it looks like kind of a junk room. But I just found this picture looked kind of nice, and I don't have a grand piano, but looked kind of nice there. But that's not real. Okay, so Fowd says the record shows severe impairment in your lumbar spine. And again, I know this sounds like a broken record. You don't win your disability case because of a diagnosis. You may have herniated discs. You may have severe impairment in the lumbar spine. The question is, what does that impact? How does that impact you in terms of working? And that's what you want to really focus on. But again, at the appeals council or federal district court level, you need an attorney to look at what the judge analyzed it. Did the judge, properly pose a hypothetical question to the vocational witness? Did the judge properly analyze the medical evidence? Can an attorney get Mooley says, can an attorney get all medical records used during the approval process? Does the attorney talk with the adjudicator, see where they are in the process? Very good question. What I do, I will tell you what I do is at initial and recon, we are always updating the adjudicator as to any new medical evidence. The reason for that is let the adjudicator earn their money. Let them request medical records. If they can't get them, we will do it. But they like to do it. And the reason for that is, again, just to be transparent with you, is that Social Security is concerned if they relied on claimants or even claimants' attorneys to submit records, there might be some scrubbing of the records. Or maybe let's say there's a page in that record that talked about, marijuana use or alcohol use or something like that. They don't want to trust that everything that they get from a claimant or an attorney is going to be completely accurate. They like to get it themselves. If they don't get it, then we will submit it. And again, I usually have problems when I submit it. They know, as an attorney, I can't leave things out. I'm not going to, scrub the record or anything like that. They pretty much are okay with that, but they typically like to get it at the first, for the first step of it. What I do is I do talk to adjudicators at times. Like, for example, if I've got a couple of cases now, kind of like cancer-free, that should be approved early. And I'll call the adjudicator and say, what do you need? And let's, tell me what you need. I'll try to get it for you. More often, though, I will log into the electronic folder. It's called the ERE file, the Electronics Records Express. I can see what they've got. And so what I will do is I will have one of my staff people make a copy of that. That's section F of the folder, send it to my client, or sometimes I'll call my client, we'll do a screen share, do a Microsoft Teams or Zoom or something, do a screen share, and we will look to see what they've got. And if they're missing something, then, I will do a combination of contacting the adjudicator, or I will, go to the portal and get it uploaded myself, depending on where we are in the process. But adjudicators, unfortunately, are so busy and overworked. They don't, I hate to give percentages, but 80% of the time you leave a message, they don't call you back. And it's not practical to continuously call when I have hundreds of cases, to call and call and call to try to talk to an adjudicator, because they don't call back. They're just too busy. So I usually just look at I can see what they're doing. And so I will do, have my client look at that. I will fax the adjudicator. I will email them if I can get the email address. And just any way we can communicate, we do. But the big picture is, we want to get that record as complete as possible. So, my office plays a part in that. But I'd say the first step is to provide the adjudicator with all the information they need to request it. They're most comfortable with that. And then we kind of go from there. Okay. Leanne says, hello. Hi, Leanne. You're 50 years old. You have liver cirrhosis, a general anxiety disorder with agoraphobia, insomnia, PTSD. You were an RN for 17 years, no work since. Seeing a psychiatric RN in therapy for 11 months, med compliant, IOP done, and sober 1.5 years. So congratulations on the sobriety. Obviously, I'm assuming the liver cirrhosis was based on alcohol use. So I would say that, the liver cirrhosis, I've got actually a case with this going on right now, non-alcoholic liver cirrhosis, but you want to get a sense from, the doctor is how damaged your liver is. What is the permanent damage to your liver because of the cirrhosis? And what is the practical effect of that in terms of your functioning? Remember, at 50, theoretically, the sedentary grid applies, but, these conditions are not really going to be so exertional. Maybe the cirrhosis might be exertional in the sense that it might prevent you from doing physical type of work, but this might be more of a overall functional capacity. I'm guessing fatigue would be a big problem. Obviously, the mental health issues, the agoraphobia would limit you from going outside. There's a fear of open spaces. Insomnia would make your sleep non-restorative. PTSD, you'd be triggered by certain things. So a lot of these things are non-exertional, and it looks to me like this is a combination case where you would almost look at each of these conditions and say, what are the limitations that apply? The cirrhosis, again, I'm thinking is going to probably be fatigue. It's going to be lack of energy. Maybe there's some restroom issues. I don't know. Maybe there's some pain involved. And so again, what does that mean? What does that translate into in terms of not being able to work, not just as an RN, but anything else for that matter? Then you look at the mental health issues, the agoraphobia, the PTSD. What does that mean? And how diagnosed is it? You're getting treatment. Will your therapist basically say that this limits you from, most employment situations where you would not be able to leave the house, or there may be, you want to be this specific, 3 or 4 days a month where because of symptoms, you would not be able to go into work. Something like that. So you want to really break it down at a real granular level to determine the specific reasons why you would not be able to work. And again, I think if I'm looking at this, I'm looking at the cirrhosis first because it's a medical problem. It's objective. It can be measured. What does that mean? And if you have a specialist, to look at that and say, this is going to cause some significant functional limitations, get those identified as much as you can. And then that would be the argument I would make. Okay, St. Louis, hello. Happy Thanksgiving. Thank you very much. I hope that you have, all of you have a chance to spend time with your friends and family. Thanksgiving is a great holiday. It's I don't think anybody can object to it. I know people are real fond of objecting to this, objecting to that, but it's the one time we get to say thank you to the people in our lives that have made it better. And, it's interesting. I'm on a couple of text chains with some friends, and, around this time of year, we get everybody's back and forth saying, I really appreciate, you being in my life. And I think that's a really nice sentiment to have, and it's good to hear. It's good to say it, and it's good to hear it. Okay, Calvin. If I have a doctor evaluating my impairment for the last year and a half, I get a new doctor, it's a good idea. Would it delay my case? I think that sometimes, Social Security recognizes that people have to get new doctors because insurance changes or the doctor retires. I don't think it's going to delay your case. The real question is, will the new doctor be prepared to offer any kind of functional assessment, or can you get that from the old doctor? I think the continuity of treatment is really important. You want to make sure that you have ongoing treatment, that there's no gaps in treatment. But the fact you've got a new doctor, the biggest issue would be, will that doctor be prepared to look at the history and their other doctors' notes and draw any conclusions, or at what point would he or she be able to draw any conclusions about your functional limitations? But you've got to, if you get a new doctor, and again, I think you're suggesting you're doing it voluntarily. The biggest question I would have would be, obviously, why is your first doctor not sympathetic to the disability concept? That may be what's going on. Maybe it's inconvenient, too far away. That could be the issue. But I think that, if you start with a new doctor, I think it's a big ask to ask that new doctor to start commenting on your functional limitations after 2 visits, after 3 visits. So in the sense that it might delay getting an assessment, that would be a downside to doing it. But otherwise, if you feel like you're getting kind of hit a brick wall with this first doctor, that may be what you need to do. Okay, St. Louis, please define marked limitation of what quantifies the term being able to function. Okay, I think that's actually a very good question. So you guys have great questions. Occasional, I believe, is about 25% of the day. Moderate limitation would be 50%. I think marked would be, 75% plus. And generally speaking, on a functional capacity evaluation or a functional capacity form, if you have 2 or 3 marked limitations in something significant, being able to maintain attention, concentration, focus, things like that. Usually it takes more than just one, I'd say 2 or 3. That's a pretty good sign. If a judge accepts that, that's usually a winning argument. So marked would be, more than moderate, and I would say 75% is kind of a good percentage in terms of the impact of your day. Marked impairment would be something that impacts 75% of the workday. Okay, Teresa, thank you. Happy, well, thank you. Alex, I'm going to call you Alex Ortiz. I don't know how, Alex Shadid Ortiz. On what is, I'm not sure, on what is focus on waiting for a date for a hearing? Oh, what should I focus on waiting for a date for a hearing? I think number one would be continue to go to the doctor. If your doctor is willing to do a functional assessment, either in a functional capacity form, or if the doctor is willing to write a narrative letter describing your functional limitations. Remember, all this needs to relate back to your capacity for work. So I think that the more you can do to firm that up, the better. I think you want to make sure you get the forms that Social Security sends you filled. You need to get those filled in. The work history form, if you have not done that. Current medication list, very important. Recent medical treatment, also very important. If you have an attorney, make sure the attorney knows about any recent medical treatment, especially any diagnostic tests, to get those into the file. Again, you've got a 5-day rule, can't be in more within 5 days, 5 business days, typically 7 or 8 calendar days of your hearing. So I think just firming up the record would be really important. Again, trying to get that functional capacity assessment from the doctor would be important. Practicing with your lawyer, the questions you're likely to get in terms of, and there's certain questions that every judge is going to ask, about specifics about if it's a physical case, sitting, standing, walking, kneeling, crouching, stooping, climbing, reaching, things like that. If it's mental, it's going to be focus, concentration, sleep. All these questions that every judge asks. You need to be able to explain in a what I call an elevator speech why you feel you're not able to work, with a focus on functional limitations. So I think those are some of the things that I would do to really prepare. I've got a bunch of videos about how to prepare for your hearing. Look at that. There are other people out there who've got videos that talk about the same thing. Educate yourself. Your attorney is going to tell you a certain amount of stuff, but I will tell you, having been in pre-hearing conferences, doing them all the time, I always tell my client, I'm throwing a lot of stuff at you, and it may be kind of hard to keep all this stuff in mind. So, educate yourself using the video information out there, multiple channels, myself included. Just take it apart and just really kind of take notes. One of my clients, Sharon, who sometimes will visit us, we got a favorable decision, and she did something kind of interesting. We're going to explore that. I think when I get back, I may reach out to her and try to kind of pick her brain about it. But she came up with little like file cards, little 3x5 file cards. And so she broke it down into very specific areas based on the questions that she was likely to get. So she had their answers kind of written on there. I don't want you reading answers, but that way you have it all in front of you. And as the judge goes through it, you take that file card and you move it out. So that way you make sure you cover everything that needs to be covered. So that was the one way to kind of do it. And just, you have file cards, 3x5 cards, and you've kind of written some notes on there. That's not a bad way to do it either. Connection, let's see, St. Louis says shaky. Yeah, that was because I went to tried to load another website, which I'm not going to do anymore. Okay, Kelly says, you mentioned last week looking at having a judge. Sounds a great idea. Yes, I talked to the judge, retired judge, last week. We are probably going to get him in February. He's actually going out of the country in first part of January. So I could theoretically get him like the first week in January. I'm thinking, let's just wait till February, the first week in February. That way, the more people I can publicize a little bit more, and more people will be, I think, day after New Year's or 2 days after New Year's is probably not the best time, but he's in. So he will be doing it, and basically we're going to ask him questions about what were the things that made a difference to him. So I want everybody here to write down questions you'd like to ask a judge, and I wouldn't ask him about your case. I mean, because I will tell you, one of the things that I see him on, some of these social networking sites, Quora, whatever, people will say, I have reduced lung capacity. Am I going to win? He says the same thing I would say. It depends on what the impairments are. But, I think just ask questions about evidence, but just, make note of your questions. I mean, send them to me if you want to. We can kind of go with a list of questions for him. But he's, really nice guy. And like I said, he's very open to answering questions. So we'll do that in February. And I'll tell you more about him as we get a little closer. Okay, Mercy Padilla. My case is in a recon. After 1 year, assigned to an adjudicator, and she sent the work experience, pain and function forms, asked legal assistance. Let's see. It's completely my forms to add under remarks. Please review this case on a grid rule. She and the attorney declined doing that. I can't. I mean, to me, if you have a physical limitation, you're over 50, or you're in 20206 would be over 55. Why not put it in there? It doesn't. I mean, it makes no sense not to. I mean, now again, the attorney may feel like you have non-exertional impairments. If your impairments are all mental health, the grids would not apply. But if you've got a back problem, if you've got knee problems, and they're significant, I think that you can make an argument you're limited to light work, 202.06 applies. So, it's really probably more on the actual form or in a letter to the adjudicator. But, I don't know why an attorney would say no to that. It just doesn't make a whole lot of sense to me, but that's just me. Is there an official definition? There might be. I think that what I would start, first place I would look is something called Social Security Rulings, RULINGS, and you might find it there. It might also be in the code, the CFR, the Code of Federal Regulations, where they define those terms. I can't look it up right now because I'd lose, you'd lose me here. But that's where I would look. Is I'd look in the code, and I would look in fact, maybe even look at the listings. It's probably listed. I'm sure it will be listed there. So if you go to meetalisting.com and you go to the listings, there's a link to the listings, and look up, maybe do a search for marked definition. I think it would be there. That's going to be out of the code, again, called the Code of Federal Regulations, is where they come by. And then look at the Social Security rulings. It would probably be in there as well. That's where I would look. Okay, and again, I would do it, but I can't. I don't have enough. I don't have enough bandwidth to do it live. All right, so cancer-free is the person who's been waiting, who's on oxygen. Applied in June. We're in late November. Reach out to your senator. That's way too long. Way too long, in my opinion. And that's not a knock on your attorney, because your attorney can't do that. You're the constituent. You're the person who is the voter. So if I write a letter to a representative, a senator, like, who are you? But if the voter does, different story entirely. Okay. Main Event says, good evening. Good evening, Main Event. Hope you were doing well. Okay. Ms. Alexander, my x-ray shows I have lumbar facet arthropathy, which is arthritis. My Emory ortho doctor diagnosed me with sacroiliitis. Will subsequently pick one? Will they use both? I'm at the hearing level. I think they're probably going to go more with what the orthopedic doctor says, because the x-ray, is one way to evaluate back problems. MRIs are probably a better diagnostic test, but generally speaking, you need it interpreted by a radiologist or your orthopedic doctor. Emory, I happen to be in Atlanta. Emory is a top-notch, medical facility. So I think that if you have an Emory orthopedist making an assessment, that would be given a lot more weight than some adjudicator or judge trying to analyze or interpret an X-ray. So I would say the Emory doctor is going to be a better choice. Cindy G, thanks. You're welcome, Cindy G. I have 43 Reyes. Thank you. I hope they have, I think it is frustrating because people always ask me why it says, I'm on step 3 or step 4. It says 45%. I don't think that means a hill of beans. I just think that it's just a number. I'll see it change from 50% to 95% overnight. So, it's just, they're way behind. And I'll tell you, you may have heard this, but Commissioner O'Malley, the commissioner who had been really doing quite a good job, I think, for the last 7 or 8 months, he tendered his resignation. I think his last day was, if not this week, it'll be next week. And he is, I think, going to be running for the chairmanship of the Democratic Party, I think is what, and probably has presidential aspirations as well. But there's going to be, the word on the street is there's going to be an interim commissioner named Carolyn Colvin. Ms. Colvin had been the interim commissioner before. I'll just leave it at, it's better to have a full-time commissioner, as opposed to an interim commissioner. Interim means that you part-time, or not part-time. It's filling some shoes until there's a new person appointed. I think Ms. Colvin was in retirement. They're not getting anything done. So I think that, I don't think anything positive is going to happen, at least until we get a real commissioner. Then after that, if the commissioner is going to be hostile towards disability or neutral or, wants to help. So we'll just have to see. Ricky and Wendy, how are y'all doing? Ricky and Wendy, how long after it goes through adjudicator's hands does the claim get to the judge? I would say, again, the time frame is, in general, now, 2024, 25. When you apply, 8 to 12 months is typical. You get denied, you apply for reconsideration. Another 8, maybe 7, 10, 12 months at recon, maybe a little bit less at recon. Then you request a hearing. It's about 5 or 6 months after you request it. The hearing stage seems to be moving a little more quickly. And that's because I think that there's some excess capacity amongst the judges. I think that because most hearings are done remotely, judges can be more efficient. So I would definitely say, after the adjudication level is going to be 18 to 24 months, maybe a little bit less, sometimes 12 to 18 months, and then you get to a hearing, usually in the 2 to 2.5 year time frame, which is ridiculously long, by the way. Okay. Arthropathy here, Kevin says, really bad arthritis wear and tear injuries, beaten up at work, concussions. Again, the question is, what does that mean in terms of your functioning? All these things could cause significant limitations in functioning, or they could cause no limitations in functioning. That you've got to quantify. Ideally, a medical doctor needs to help quantify that, but that's the main issue. And I'm sorry you went through all that. Melinda says, can you get disabled check for ulcer surgery? Again, Melinda, the question is, two questions will arise. Number one is, you had an ulcer before the surgery. How long did you have it? And how bad was it in terms of keeping you out of work? And then after you had the surgery, did the surgery successfully resolve the problem? To win disability, you've got to be out of work, unable to do really any work for 12 months, 12 consecutive months. So if this all happened, you got diagnosed, you had the surgery, you're back to normal in 7 or 8 months, you ain't got a case. If it's stretched out over the course of a year, maybe you have a closed period case, maybe you have ongoing disability. But the real question in my mind would be, obviously, an ulcer that required surgery sounds pretty serious. So how long before the surgery were you impaired? Did it stop you, prevent you from working because of just terrible pain or whatever the other symptoms you might have had would be? And then after the surgery, has it resolved it? You got to meet that 12 months, and you have to have during that 12 months evidence that you would not have been able to do any kind of work at all. Mango bomb squishies. Okay, that's interesting. I'm sure there's a story behind that, but okay. Hello, Mr. Ginsberg. It's Jonathan, not Mr. Ginsberg, but hello, Mango bomb. I have a previous case I opened in 2015, which was denied for lack of evidence, no appeal. In this February, denied for lack of medical evidence and no appeal. Can I ask the current one with the adjudicator that I started in 24 be added to the original application reopened case? Well, the rules on reopening, generally speaking, are, and what we're talking about is if you're denied, you file an application, you get denied, you don't appeal it, then you file a new application. Can you go back and ask Social Security to reopen the old application? Generally speaking, you need to have the initial denial needs to be within 1 year, not the application, the initial denial within 1 year of your new application. Then you can ask to reopen. It is voluntary on their part. They don't have to do it. And really you have to show there's something they didn't have, typically medically related. So some medical evidence that they did not get. So your argument would be, when I applied back in last year, there was MRI records that you didn't get, or you requested them, they didn't come in. I'm applying again. These records were in existence back then, but you didn't get them. I want my claim reopened. That's the strongest argument for reopening. There's some really unusual circumstances where in SSDI you can go back up to 4 years if you can prove they misled you. Almost impossible to do. The bigger problem here is that you're saying to me there was no lack of evidence. So reopening an old case, you need to show there was something they didn't get. So if there was a lack of evidence, or is no evidence, you're not going to get a good result. You've got to have medical evidence. If there was evidence they didn't get, different story. But that's the real question: is do you have evidence to win? Hello, Madeline. Madeline is works as a legal assistant, call screener in my office. Does a really, really good job, and is that friendly voice that many of you who've called my office will talk to. And we rely on Madeline for a lot of things, more and more things. So hello, Madeline. Hope you're doing well tonight. Johnny, happy Thanksgiving. Thank you. Our family lost a loved one. My dad's niece passed away, so we're managing to get through. Sorry, it just shows you how unpredictable life can be. And I'm assuming that your dad's niece, is probably not an old person. Again, it's a tragedy when somebody, in their 20s, 30s, 40s passes away, no matter what the cause. But I wish you peace. I mean, that's terrible. And so, I guess Thanksgiving is, you got to be thankful for what you have, and maybe rededicate yourself to recognizing that life is very short. So make every day count. I think it's really the only positive you can take away from something like that. But I'm sorry to hear it. Thank you, Muley, and you have a happy Thanksgiving to you as well. Lulu, if you meet the grid rules, I will not report you have to go to hearing. Okay, so Lulu says if you meet the grid rules, okay, and you have all the doctor's reports saying you have to go to the hearing, you have to convince a judge that you meet the grid rules. Now, I've had cases literally where I get a call from the judge the day before the hearing. The judge says, I'm looking at this and your client meets the grid rules, no reason for a hearing. Or sometimes I do it in a brief. I typically do briefs in most of my cases. And so I'll make the grid rule argument. And sometimes I'll get a judge's assistant will contact me and say, judge is going to grant your case. So yes, it is very not unusual, not unlikely if you meet the grid rule and the evidence is there and you let the judge know about it ahead of time and realize they're really busy. So you got to point it out to them, but you don't have to go to a hearing if in fact the judge sees it that way. Now the judge may say, I need to make a decision about transferability of skills because that's an element of the grid rules, or I need to make a decision about your functional capacity, whether you're light or medium or sedentary. Or the judge may just want to see you, ask questions, maybe some issues about alcohol and drugs. I mean, it can be a number of reasons why a judge wants to see you, but if the judge wants to see you, got to go. But the judges like to take care of cases without going to a hearing if they can do it, because it saves their time and gives them more time to deal with other cases. So they don't have to have a hearing, but it's just a matter. I think that the key is to get the information to the judge early, making your argument very, very clear as to why you meet the grids. And that's why the grids are so great, by the way. What is this processing time for SS for reconsideration? Michael asked. Already 7 months. I would say anywhere from 7 to 12 months. If you're in Texas or Florida, 15, 17, 18 months. Texas and Florida are just a mess right now. Not sure why. Kevin Johnson says, still at recon, age 59 in January, bad left knee, have updated MRI. The orthopedic doctor says surgery for a whole new knee, where the grid rules for me, recon started May. Okay, I would look at the light grid rule because, I think that if you have a bad left knee that you're going to need surgery, a knee replacement or some sort of invasive surgery, you're going to have a hard time doing light work. What is light work? Standing on your feet, standing and walking 6 out of 8 hours in a day. I'm guessing that would be hard to do with a bad knee. So that's really the question there is, could you do that? And then the other question is, for the grid rules at light, do you have any transferable skills from past work that would apply to a sedentary type of job? Or is there something else going on? But I think that, I would make the argument at the recon that you meet the grid rules, and I get a lot of approvals at recon under the grids for that very reason. Because once you're over 55, as long as you can prove you can't do light work, you got a good chance at winning. And again, with a bum knee that needs surgery, and you didn't say what kind of surgery, but a whole new knee replacement surgery. They're not, I think nobody's going to expect you to be able to stand and walk 6 hours a day. So I think, that's a good grid rule. That's a very good grid rule case, is my opinion, based on what I'm seeing there. Okay, R says, hi. Oh, clapping hands. I'm age 60 in Illinois. I've been waiting since February for initial determination, CE. They need no test. What gives? They're just overworked. They're overworked. I mean, I think that, the CE, the consultative evaluation, they don't have to do them. They many times will do it. If you didn't say whether you're represented or not. If you're not represented, you have, objective evidence in the form of MRIs or things like that, or other reports basically talking about, your functional capacity. If you're physical, about you're be limited to less to light work or less, you might meet the grid rule at 202.06, for example, is one to look at. Gridrules.net is the website. Let me see if I can put that on here. Again, I don't want to switch over to it because it's going to, that's the link to the grid rules. But it's just they're overworked. And I think that you've been waiting since February. Reach out to your senators and say, I've been waiting since February. I'm over 60. I've got significant problems. They haven't done anything on my file. Will you create a congressional inquiry? And that's what I would do. Okay. All right, let's go back up here. Hyacinth flower. Okay. Can you discuss claims with the conditions in the compassionate allowance list? My husband has 2 breathing issues on the list. We do have an edge over these conditions. Yeah, of course, if you meet the compassionate allowance and it's hard to meet, and realize compassionate allowance is a subset of the listing, but if you can identify the compassionate allowance, let the adjudicator know, please evaluate this case under compassionate allowance, DI, whatever the number is, that would be helpful. This is also where maybe reaching out to your representative would be and saying, look, I'm on a compassionate allowance case. This case needs to be approved quickly. Will you create a congressional inquiry to expedite the process? That would be the steps I would take. Christina says, please don't forget to like. Thank you, Christina. I'm not sure. Obviously, the quality is not as good as I normally get, but I still hope you guys like this. Ms. B. Okay. Hope I have several questions. I'll see if I can work through that. And before I get to that, let's ask here. Roger Ray. Hey, brother Roger Ray. Thank you for what you do. Question, they only back pay disability for 12 months. You get paid 12 months prior to your date of application, not the date of decision. So if you applied in February of 2024 and you allege an onset of, let's say, July 2021, you can get paid. The 5 months runs as of the onset date. So you can get paid, you can apply in February 24, you get paid back starting in March of 23. So it's 1 year prior to the date of application. But realize that there's a 5-month waiting period involved in that, and your onset date has to be more than that. So typically, if your onset date is more than 17 or 18 months prior to your date of application, that's how you max out your benefits, if you can prove it, because the 5-month waiting period runs, and you got that 12 months you can get. So if you can use up the 5-month waiting period during a time when you're not eligible for payment, then the 12 months you are eligible for payment, that's how you max out your numbers. Okay, Ms. B. Denied the recon stage, and this says that I've done, despite my impairment, that I'm able to do some sort of gainful work. And that's the boilerplate they use, that you're able to do gainful activity. So that doesn't mean anything. It's just boilerplate. There's probably going to be another part of this question. Here we go. I asked my pain management doctor to request an SC about a month before the decision. It says you can do sedentary work. Okay, well, that's, again, evidence that's going to be pretty compelling. If you are over 50 or over 55, you got the grid rules there. If you're under 55, under 50, you got a problem. But he also described the symptoms I experienced in front of me, still put sedentary as less than sedentary. Now, let me add this one little wrinkle to it. Having the capacity to do sedentary work means that physically you have the capacity. There may be other issues that are not considered by the functional capacity evaluator. You may have severe depression. You may have some sort of mental health issue, some sort of a non-exertional impairment that reduces, that makes you unable to work. So I would look at all of the factors there. Don't want to get a lawyer, but I either have to request hearing or refuse the next day with the next day of 10/20 from the 8/5, which is the best way to proceed. I don't want to get a lawyer, but I either request hearing or refuse with the next day of 10/2 to 8/5. I don't understand what that means. I'm sorry. I apologize. Can you explain that further? That would be helpful. I just don't know what you're asking me there. Okay. We'll get back to you though, Ms. B. Don't worry. But I think your age is going to be real important here. Okay. Metal Mike. Let me change the banner here. And I'll just put that one in there, because I've used this program called StreamYard, and it allows you to put these banners in. So that's what I was just doing there. Okay. Metal Mike says, what if your psychotropic medications are not working or causing severe side effects? Have you seen a judge have a disability claim for somebody having problems with medical meds and only doing therapy? I think, I think that judges realize that medication side effects can really be a problem. They need to be well documented. You need to have your doctor, psychiatrist, try you on different medications and put in the record that you were just not tolerant of these or they were not effective. I don't know that you saying I was uncomfortable is going to help you that much. I think it needs to be coming from your doctor. Yanni, I'm a young adult, 24 of age, without any work history of chronic knee dislocations. Was mental health issue. I filed for disability denied. File again. Well, you're not going to get SSDI if you don't have a work record. So you're going to be applying for SSI. I think number one, being 24 is a real issue because Social Security makes it really hard to win at that age. You got to really show you can't do anything. There's got to be extensive medical treatment. I think that chronic knee dislocations, the question would be, could you do a sit-down job? And even if they don't consider, by the way, getting to and from work. So that's not a factor here. The question, if you got to work and they give you a sit-down job, could you do it? You're going to have medical evidence, strong support saying you could not do it. Again, right now, it sounds like you're in SSI land, unless you're a disabled adult child, a whole different issue. But, you're not going to be able to get disability, SSDI disability with no earnings record. So you're looking at SSI. I would tell you, I think it's also, and again, I don't know your situation, obviously, but, maybe try to work, see what happens. I think that shows your effort to try to work could really be helpful if you're going to pursue this. I think a 24-year-old who doesn't really have any work history, it's going to be a problem. The mental health issues I know could be an issue there. It's just hard to win at 24. I'm just going to tell you flat out. I'm almost never going to take a case of somebody that young. It's just too hard to win. And we get paid a percentage. We get paid only if we win. There's a certain percentage of the judges. I'm guessing half the judges out there, just by default, are not going to approve anybody unless you're in your deathbed at 24. So, the odds of getting an approval are just really, really small, unfortunately. Ms. Alexander, thanks. Thank you, Ms. Alexander. I hope you have a happy Thanksgiving as well, and I hope you enjoy your meal with your family, which is the most important part. Madeline, okay. Okay, Madeline. If someone is on workers' comp that ends in January 25, accidentally applies for SSDI while looking at the application, should they answer SSA's questions to continue or start again in January? Realize you can always amend your onset date. So if you have an active application, I think that there's no reason not to stick with it. Now, workers' comp brings with it certain complications, and I think we probably talked about this, and that is that there's something called a Medicare set-aside, which basically means that Medicare does not want to pick up the medical expenses from a work injury that should be covered by your workers' comp insurance company. So many times the Medicare set-aside will say that you're agreeing not to apply for Social Security for 2 years, 3 years, some number, and so that you can use up the money in your Medicare set aside. I think before I would do anything, I would talk to your comp lawyer. I would tell that person to talk to his or her comp lawyer and say what happened. I didn't really mean to apply, but I did. Should I just keep this one ongoing and then, maybe change the onset date or deal with it? There's going to be an offset for that month, the couple of months, because workers' comp offsets Social Security. But, having the active case going has got some value as well. I would say talk to the comp lawyer, but I do think that the Medicare set-aside issue could be one that pops up, and that can get kind of squirrely because, I've seen situations where somebody, is under workers' comp, they're getting comp benefits. Unbeknownst to their comp lawyer, they file for Social Security disability. Boom, a case that otherwise did not require Medicare set-aside now does. So it can make the comp case a lot more complicated. Now, whether or not dismissing your case would, resolve that issue, or once you filed, I don't know. That's where your comp lawyer would be able to help you, I think. Okay, one more question. What if your judge's approval rate? That's great. I mean, if you can get a judge at 65%, you're doing great. I mean, the average is like 48%. Now, I won one with a judge in the 30% range the other day. So it can happen. That was a really good case. But 65% is well above average, and that's great. That's a real lucky bonus. That's great. Do you have veterans with SSDI claims for PTSD? Asked Benny DeMarco. I look at every case kind of separately. I will tell you that PTSD is difficult because it is invisible. I'll also tell you that many people that are treating at the VA for PTSD, the VA tends to give people a lot of medications. They put them in group therapy. PTSD is an anxiety disorder. It needs to be really severe. I think that even if you're 100% VA disabled, it's not going to be binding on Social Security. You've got to prove that your PTSD is such that you would not be able to reliably perform any kind of job because the triggers are so frequent, the reaction is so unpredictable and so long lasting. But you need real support from the therapist, ideally a psychiatrist and a psychologist. VA, in my experience, is not the best place to get that. So the answer to your question is, yeah, I take those cases, but only if the medical evidence is really strong because they are hard to win. And I would and realize that most veterans, especially those who've served our country, which we are thankful for, and this Thanksgiving I certainly am, but many people who've served, who've been in combat, are going to have PTSD. So it's not an uncommon consequence of serving our country. And the VA, I don't know if y'all remember, a number of years ago, there was a big scandal where the VA instructed their doctors not to diagnose PTSD because it was causing too many VA claims. That got found out by a media outlet, and they VA had to wash it or come clean with it. But I think that PTSD cases are hard unless there's really, really, really strong evidence. So that's what I would tell you. That's what I would look for. Can't speak for other lawyers. So that's what I'll look for. Kay Wolf. Hi, Kay Wolf. Happy Thanksgiving. Thank you. I appreciate that. All right, Ms. B is the question. Is a person who has questions before. I currently have FSCR. My cervical disc wants to treat me for cervical CRSP, but night dose with a bit of bad nerve pain for the neck down. Basically, I was using my left arm. Okay, so I'm guessing facet syndrome and something in your cervical spine. So I guess, again, the question is, you didn't say how old you are, I don't believe, but, if your limitation is on your left arm, there are jobs that can be done with the right arm. So, that's going to eliminate functionality from many, many jobs. Obviously, not being able to use both hands. The pain issue is going to be a big factor. If you have significant pain with even minimal use of your either hand, or even no use of it, that could be a real factor there. So I think, again, all these things have to kind of put together, but realize you've got to prove there's no work at all you could do. You simply are just too much pain, too physically limited to do that. But it needs to come from a doctor, I think, is really what's going to move the meter there. 48. Okay, so you're not going to be in the grid rule area. I'm going to stop my sling position. What listing? I think you can look at listing 1, but it's going to be hard to meet listing 1. They just made it really, really hard to do that. I would look there. And there's one that talks about inability to use one of your upper extremities, which is what you've got here. But I don't know that that's going to be enough. So now you're too. You could certainly make that. Oh, being on vacation means I was doing a lot of walking, and I took a tennis clinic today for an hour and a half, and the guy ran me around the court. So it was pretty intense. So I'm a little still kind of recovering. I managed to eat a big plate of eggplant parm tonight and some ice cream to kind of restore my energy in preparation for this. So you're welcome. But still kind of tired from all the running around. But anyway, okay. So 48. So you don't meet the listing. You don't meet the grid rule. You could argue a listing. Again, I'm not going to go to it because you'll lose me. But I think functional capacity might be your best argument here. And you're going to need to show, obviously, you can't use your left arm. It's probably non-dominant if you're right-handed. So if you're not able to use your non-dominant hand for much of anything, there are jobs you could do with the other hand. the question is going to really be, is the pain level so severe that you can't do anything at all? So I think that, what I would say is if you can get your doctor to fill out a functional capacity form, I think I got a link to that here too. Yep. Okay, so that is where you can get free functional capacity forms. Get one that talks about physical limitations or orthopedic limitations. See if your doctor will fill that out. Keep a pain diary, but I think those are going to be the 48 right there is you're not at 50, so that 50 is kind of that magic time. And I think if you were 50, you might have a better argument for a grid because lifting and carrying is part of the grid rule. And if you can't, if you only have one arm, not going to be able to lift and carry very much. But I think that functional capacity is probably going to be the best argument. It's probably going to be reliant mostly on pain, would be my guess. Okay, let's see here. Okay. Luke Rogers says, I have chronic pain, severe mental imbalance, and sensory medications. In a psych hospital 20 years ago, traumatic brain injury, been barely hanging on, 43 now. 43, not 50. Although with mental health cases, it's probably a little bit less important. I think that, it's going to come, the 20-year psych hospitalization, that's kind of not going to help you all that much because, in my opinion, because it's just too long ago. I think you're going to need really good support from your treating psychiatrist that basically says you're medication intolerant, your functioning is significantly limited. If you've got chronic pain, what is the source of that? Do you have a doctor who'll be able to talk about that? This is going to be a combination argument. There's physical issues, there's mental health issues. How has your functioning been limited, but what will the doctor say about it? Not what you say, what is the doctor going to say? What kind of treatment have you gotten? You mentioned the severe pain. Is there objective evidence of that? Are there MRIs? Are there CTs? Is there some nerve conduction study? Why are you having pain? You need to be able to explain why. And how does it limit you? And with the mental health, again, you're going to need ongoing treatment records to show that, in fact, you are not responsive to medications or too intolerant of them, and that your functioning is significantly limited. If you could get a functional capacity form filled out by a treating psychiatrist, that would be very helpful. I'll put it on again where to get that. And here, this is where you get them for free. So I would get a couple of those, and I would see if you can't get your doctor to help you with that. Okay. Thank you, Christina. I really appreciate that. So look, these reviews, again, as a lawyer, I'm in business, obviously, and people it's like anything else, they look at reviews. And so I've had some really nice reviews. People find that whether it's the videos or these live streams, very helpful. And if they're nice enough to say that, Google sees it, other search engines see it. It makes a big difference. So I do appreciate if you're getting value out of this, take a few minutes if you would. If I can humbly ask you to do so and leave me a review, that would be really, really appreciated because it does really help me, my business. Part of the reason I do this is because I'm, generally I want to share what I know, but I got to keep the lights on too. So, okay. KJ says, it's a good idea to ask my lawyer to send the AJ pre-hearing brief. Well, they're absolutely, and many I will tell you, I do them in almost every case. And I would say at least half the time the judge, will thank me for it. Appreciate you setting out the argument you made. Again, sometimes it causes the hearing to last 5 minutes. Sometimes I get a approval for the hearing at all. I like them because I will refer to the brief instead of an opening statement. And the reason I'm doing that is because hearings now are pretty much 45 minutes. And, for me to sit there and blab on for 5 minutes about my opening statement, if I can do it in writing beforehand, that's 5 more minutes for my client to testify. So I would rather do it in writing. I can make my wording exactly what I want to say. And so I find that that's a real effective thing. I think it also sends a message to the judge that you're prepared, that you know the file, you have a compelling argument, you know what you're doing in this area. I think there's a lot of good reasons to do it. So I would definitely say to do so. A pre-hearing brief. Donna, 58, tuning in again. Thanks, Donna. Trying to understand going forward how I can be approved. Depression, abdominal, perimenopausal symptoms, not experiencing memory loss. Again, Donna, it's not going to be so much about the symptoms. I'm sorry, it's about the diagnosis, but it's the symptoms and how they affect you in a work environment. So each of these issues, how does the depression leave you unable to function appropriately? Does it interfere with attention and concentration? Does it interfere with interacting with coworkers and supervisors? Emotional stability. Again, get a functional capacity form and look at all the categories and say, fill it out yourself and see what it looks like. You're going to have support from your doctor. You're going to need ideally a psychiatrist or psychologist to complete a form that identifies significant functional limitations. I think with some of the abdominal and those issues, female issues, whether it's a gynecologist or your family doctor to talk about, how does this impact you? Would it cause you to miss 1 or 2 or 3 days of work a month? That's what is going to be really important. It's about reliability. So your functionality and your reliability. Can you get your doctors to comment on that? And the memory loss obviously is going to impact you in terms of your focus and concentration, but you need your doctor to be able to identify specific work activity limitations that prevent you from being a reliable employer. Okay. Okay. Oh, our pleasure, Donna. And again, I think that every attorney is going to have a different opinion. If we weren't able to help you, just because I'm looking for evidence, and one of the issues that I have to deal with is that you have people that I really believe are disabled, but they can't afford to go to the doctor. They don't have insurance, or there's some other issue prevents them from going to the doctor. Even if I believe they're disabled, if I can't prove it, I'm not doing anybody any good. But again, everybody's got a different opinion on it. Emily, okay. Emily says perimenopause is not going to get you SSDI, if only. Probably not. I think any condition that is common, it's got to be the more common the condition, the more severe. My hand's kind of looking funny with this because of this background thing. But the more significant the evidence has got to be. And so, things like back pain, depression, menopause, these are all conditions that can be significant, but they got to be more than mild to moderate. They got to be really severe. Tammy, yes, Tammy. Thank you. I appreciate the kind words. Okay. Well, listen, I really appreciate that. I think, if I'm not mistaken, I was working on your application just the other day, maybe yesterday. So, we're looking forward to working with you, and thank you for tuning in. I really appreciate that. And we're going to do our best to get you approved as quickly as we possibly can. Got an email today. Not sure what that means. Okay. Therapy only, not real good. Yeah, I think that's a good point. I think you need, a psychiatrist is going to be, because typically with significant mental health problems, judges, in my experience, are going to look at medications. They're going to figure, well, if you've got really severe problems, medication is what the general way that's being treated. If you're going to therapists, there are some people, who are going to therapists, but like, for example, I've got a case, a very, very strong mental health case. And the claimant is seeing a psychologist who's very responsive to me. If I email him, he'll email me back. I'll call him. He's very good. And he also sees a psychiatrist. And, the psychologist will write a letter for me. And he has written letters saying, these are all the things that are going on. But the psychiatrist is prescribing the medication. And so what I'm going to need is a psychiatrist to say that this guy is still, he's been hospitalized. He's self-medicating with alcohol. All these things, but the psychiatrist needs to say that he's just not responding to multiple different medication trials. He's had multiple inpatient hospitalizations. That's what's going to win this case, and it's going to win. But that's what it's going to take. Okay, they think you to reapply, go to hearing. Okay. So you're saying, I see what you're saying. So you've got to, the 10-2 is the day they give me to reapply. Well, 10-2-24 obviously is more than a month ago. So if you missed that, again, you can ask that they, and I've done this a number of times. You can, if you miss the 60-day deadline, you can ask for good cause to get an extended deadline. And I think it's Form 795 is when you would do that. But you need to explain why you missed the deadline. If in fact that's what you're saying. Okay, I see what you're saying. Email case's been filed. Okay, so you're saying that. Okay, I get what you're saying. So you and I have not talked, is what you're getting at. Okay, and that's probably because this past couple of months I've been doing a little bit of traveling and so forth, and we've had a number of cases. So it's not, no, I will call you, of course. We always call my clients and discuss the case. I always find though it's more important to get the case filed. If we have a good case, I look at them, of course, I'm looking at everything, and we decide it's a good case. I'd rather get it filed today than call you next week. So I'll make sure that Madeline's watching this, and probably Jen is as well. So we'll make sure to get you on the calendar. To call. In fact, I've got a Calendly. I always have Madeline send out, and she has people just find a time that I'm open, and that way we just set up a time we can go over your case and talk about your strategy. But yeah, that's what I typically do. But if you're asking me, is it unusual for me to file a claim when I've not spoken to you? Other people in the office have. I will do that sometimes if I'm really busy and I want to get the case filed. So that's what's happened here. But we will definitely talk very soon. Okay. Broke dance mom. Confused about back pay. It's only 12 months. Applied in 22. I'm currently in reconsideration. Okay. So again, if you applied in January of 22, you can get back pay going back to January or February of 21. If that explains it clearly for you. Disability began a year prior to application. So so if your disability began in January of 21, let's say January 5th, 2021 is your onset date, you will not get paid for the remainder of January. You will not get paid for February, March, April, May, June. You start getting paid in July of 21. And that way, because the 5-month waiting period, 5 full months. So even though you applied in 22, you'll get, 6 months of past due benefits. Okay, but an SSD like it is for 11 years now, 16, having surgery for total hip replacements. How I received it? Will having surgery affect my SSD and my next CDR? In theory, if the surgery restores your function to a point where you'd be able to work reliably, it could. Now, I would argue that, at 60, you're not on the top of the list for them to do a review on. Number one. Number two is that at 60, you have no past work because you haven't worked in 5 years. And so the grids at 202.06 would apply, which says that basically, even if you could do light work, which is standing and walking 6 hours out of 8 hours in a day, lifting 10 pounds frequently, 20 pounds on occasion, you are still disabled. So then, in other words, they would have to prove you can lift 50 pounds on occasion. Probably not likely it's going to happen. So I think you meet the grids. I think it's unlikely going to be reviewed. But if they ask about the surgery, and they will, and the CDR, you see I had it. The question is how much of your functionality has been restored. Emily, no, it's not. You get. I see what you're saying. Okay, you can go back up to 1 year, but you could have. I have cases where I have people that get $100,000 of back pay because it takes 3 or 4 years for the case to work through. Maybe there's been an appeal. You can go back a year, but you can go. Between the time you apply or the time of your onset date and the time of approval, 3 years may pass, 4 years may pass. So you can get 3 or 4 years of past due benefits. But you can only go back 1 year to start it. But in terms of the total, it can be 36 months, 60 months. I've seen cases where, after 2 appeals and federal court and all that stuff, 10 years of past due benefits are paid. Okay. I skipped your question. Did I just ask your question, Luke? I thought I did. I think I went back to it, didn't I? Oh, okay. You asked me, have chronic pain, severe. Okay. That's the one, in IBS and insomnia. Yeah. Okay. So again, I think that this is a combination case. And so the underlying medical issues, the diagnosis is not the question. The question is, what are the functional limitations? IBS is going to cause, in many cases, excessive restroom use. That's going to interfere with your ability to work. So the question is, can you quantify it? How often you go? If you go 17 times during the day and you got medical support for that, you're going to win. So I think it's really about translating the diagnoses into specific work limitations. Okay. Loss says, federal court, how long does the process take? Going in 3 years? It just depends on the court. So there is no specific answer, but normally it's going to take about 8 or 10 months for the federal court to make a decision. Okay, so Luke's got IBS, insomnia, bipolar. Again, all these things. What is the functional effect of all this? What is the practical effect of all this on you? And I think, again, I would make a list of those things, each of your conditions, and make a list of all the things that limit you arising from that condition, and then see if your doctor will say the same thing. That's sort of the shortcut, if I had to say. Christina, sorry, who's always asking people to like and share. I was told there's 6 new rules for SSI yesterday. It's possible. I have not seen them. I will take a look and we'll talk about it next week. I don't know. I've not seen anything to that effect, but it could be. I think the one thing I did see was there's some rules about overpayment recapture. That was what I did see. That basically, if they overpay you, they're not going to take all your money. Basically, they'll do it over time. Is what I know that those came down, but I'm not sure of anything else. Lanoche, my hearing was a month ago. The focus was on mental health. Received treatment. I think that if you just started a new doctor, I would tell your attorney about it, but it's probably going to be too late to get it in for this particular case. Now, your attorney, if it's really significant and very helpful, your attorney might reach out to the judge and say, my client just went to a specialist and there's some new stuff here. You want to hold another hearing? You want to leave the record open? So you can certainly do that. Okay, I think we talked about this, Ms. B. All right, so all right, let me go down and find some ones that are not. Okay, so Luke, okay, yeah, so I think we just talked about that. I think each of these conditions is going to be, you have to identify the functional issues there. The 20-year-old psych hospitalization is not going to make, I don't think it's going to be a big factor here. Broke dance mom, 52 major depression, anxiety, undetermined DVT. That DVT, I get good results with those cases because you have to keep your leg extended. Counsel weakness, psychosis, ECT. ECT, you're having electric shock treatment. That's pretty significant. So I think, again, you're still going to need your psychiatrist or psychologist to talk about the practical effect, but they don't, ECT is that's kind of a last resort type of thing. So that is a sign of severe depression. I would tell you that. So, yeah. Okay. So look, if you got good records, that's going to help. Definitely help. Kelly. Okay. I don't know if you sent. I'll have to look again. Like I said, we sort of took the week off. I'm working a couple hours a day, but I'll make sure that we get back to you on that. In fact, like I said, I hate to go to another window because I'll maybe make a note of that here. I got to call somebody and I got to check on Kelly's. Okay. Just made a note of it, Kelly. Yeah, actually, Jen, my paralegal, is in her family. She's in Nebraska. I think she told me she was going to Minnesota to visit her husband's family, and it's snowing there. So she's kind of, again, keeping an eye on things, but, we're all kind of working part-time a little bit this week. I just figured, everybody needs to recharge their batteries. Okay. Have you ever seen a situation where a case assigned to judge one gets switched to another judge? Yes, I've seen it. It doesn't happen very often, but I've had it happen a couple of times. It's good, where I go from a 30% judge to a 60% judge. That's a good thing. I've also had it happen where I had a good judge, and they switched it out for a not so good judge. You can't really control that. In fact, there was an interesting issue that popped up on the NOSCR listserv the other day. Somebody raised the question of they got an unfavorable decision, but the judge who tried the case didn't sign it. Another judge did. Is that appealable? I think it probably is. But Social Security can change. They're not obligated to. If they give you a judge on the hearing notice, they're not obligated to ask your permission to do a different judge. Okay. Okay, psychiatrist that far back. Okay, so Emily's responding to, I think, Luke, that a psych hospitalization 20 years ago is probably not going to be all that relevant because it happened. Obviously, it happened a long time where you were able to work after that. Is the reason why. Emily's visit was much more recent, and that's going to be much more relevant, I think. Okay, Madeline responding to Donna. Very good. Okay. And thank you, Madeline, for your hard work. This last, probably, I don't know if it's been quite a year, but it's been almost a year, I guess. Dolo Dave 7414. Been denied twice from recon, been in psych treatment going on 3 years. Primary symptoms of pain, staking in the medical review process again. Yeah, again, psych cases are tough because you can't take an MRI of the brain and say this person has severe depression or anxiety. So they rely on what the doctors say. They rely on your testimony. They rely on third-party testimony. And they also, but I'll tell you, they're suspicious that doctors are overstating the person's limitations. So, they're just hard cases. I mean, there's, you can win them, but you got to really convince the judge that this is a significant case that is non-responsive to treatment, that is, the person has been being compliant. There's no drug and alcohol that kind of mess things up. And those are just tough cases. Not impossible, but tough cases. Metal Mike is 26. Will affect your case for schizophrenia. 30 documented jobs where have been fired. Panic attacks. I think that I still say mental health cases, the age is not as important, but it's still important. So I think that, 30 jobs and evidence of that is certainly evidence of a significant problem. If you've got a treating psychiatrist, you're not responsive to medications or not tolerant of them, I think that there is certainly a possibility there. Yeah, I mean, because, if you think about it, a person with significant mental health condition, whether you're 25 or 55, it doesn't really make any difference. The condition's the same. It's not like, you have a back injury, a 25-year-old is likely to be able to be more resilient. Mental health didn't work that way. So yeah, I think there's certainly an argument, and that number of jobs is pretty odd. It's pretty unusual. So yeah, I think that's definitely a situation where you might have a good argument. Sabrina says, husband was just sent to a doctor evaluation for a year, initial application, but take a long to get an answer to that. 63, severe spine problems. Yeah, I mean, again, this was one of these situations where what's taking him so long? I mean, this case he ought to grid out, he ought to be approved. This is where, again, I would reach out to my U.S. Senator. I think that would be something, because that's a winning case, I think. Okay, the ALJ sent you to a not Della, says, Dahlia, I'm sorry, Dahlia. The judge will send you out to a consultative last Tuesday. How long did the doctor send the medical report to the judge? Normally, the report gets in within about 2 or 3 days. The judge will send a copy of the report to you and or your attorney for comment, to request a supplemental hearing, to ask questions of the judge. But normally you should get the letter, your attorney will get the letter probably about a week. So that's pretty quick. Your attorney will have an opportunity, or you, if you're not represented, to respond to that. And then after that point, again, you have the right to ask for another hearing. You have the right to ask questions of the doctor, or you can leave your comments and say, make your decision. So it depends on what your response to that would be, or your attorney's response. Moonlight, advanced ankle arthritis can qualify surgery done. Again, I can't answer that question because it just depends on the functional limitations, how old you are. If you're 56 with advanced ankle arthritis and you were out for, you couldn't work for the last 12 months, you probably have at least a closed period case. If you're 25 and, or 35 and you've got advanced arthritis and you had a surgery all within the course of a year, you have no case because you didn't meet the 12-month duration. There's just too many unanswered questions there. And Emily makes a good point. That is the question of how does your medical issue keep you from working, and not just your past job, any job, even a simple entry-level kind of job. Freedom is 60 years old, been on SSDF for a year. This is 5 to 7 year review. Well, I think you'll get a review. No, because you're going to be at retirement age by then. There's no reason to do a review. So I hope that's the case, but I think you're not going to be reviewed. Thank you, Christina. I really appreciate that. Let me put I'm just going to put another banner down here. Okay. All right, Emily suggests that you avoid ECT. Some of these therapies, last resort therapies, ketamine, ECT, you do your research, do your homework. I mean, Emily makes a good point. It's pretty significant to go through ECT. So I would say do your research, do your homework, and make it, get a second opinion, at the very least. Tony, small, almost 52, L4-5 fusion last year, back to work in November. Still working a great deal of pain. Pain is worse than pain meds that affect your concentration. As long as you're working, you're not disabled. So, I would say, that at 52, you would need to meet the sedentary grid. If you're able to work, you should work. If you get to the point where you can't work, then I think you would certainly could pursue disability. If you were 55, it would be a much stronger case. So if you can manage to survive until 55, your case will be stronger. It's probably not a bad case at this point. A fusion, and if the fusion, you need evidence that the fusion was not entirely successful. There was some sort of a nerve issue that the fusion did not take. But simply having a fusion doesn't make you disabled. But your doctor is seeing that you're still in a lot of pain. And again, you say September 23 of November 2023. It's been a year, but you're able to work. Social Security defines disability as not being able to work. So you got to be, it's got to get to the point where it would stop you from working. But again, I think if you were 55, your case would be significantly stronger because of the grid rules. Thank you, MyFi. Happy Thanksgiving to you. Thank you. Been a subscriber 15 years. Watched all you. Okay, great. Question is you're watching our I really appreciate that. I hope you find them useful. That's why we do them. And yeah, it's fun. I don't know. Maybe it's been 15 years. I don't know. I thought it was like maybe closer to 10, but I'd have to look when I did the first one. But I'm glad that we've provided you some knowledge. I hope you're educating yourself with all this. But thank you for commenting. I appreciate it. Tony, I can't. How long before you get approved? If you're working, still working in a great deal of pain. If you're working, you're not going to win because working is, by definition, to be on disability, you have to show you can't work. So you're not going to win if you're working. And if you do apply, and again, looking from their perspective, let's say that you stop work tomorrow and you apply. Social Security is going to look at you and say, well, you haven't been out for a year, so we don't know if you're going to be out for a year. So, but you're able to work after the surgery. Now you're saying things have gotten worse. How do they know that you are not able to work for a full year? Now, the whole process can take 8 or 9 months. It's going to use a lot of that up. But if let's say 8 months in, you get a denial notice because you haven't been out of work for a full year, so they don't know whether you're going to be out for a year. Unless there's evidence to say you will be out for at least a year, they're not going to assume anything. And you're 52, and so you have to meet the grid, you're going to have to show you're limited to sedentary work, which is no more than 2 hours standing, 5 pounds frequently, 10 pounds occasionally. So that's a harder road than to light grid of 55, where you have to show that even if you could do 6 hours standing, you're still disabled, and lifting 20 pounds, you're still disabled. So it's a much more generous grid argument. Addison's disease, again, how severe is it? What is it? What are the implications of it in terms of working? Yeah, JFK did have Addison's. Okay, now retro and back pay are the same thing. Retro pay and back pay is the exact same thing. It's just it's a synonym for one another. So again, you can get paid up to a year prior to application, but the amount of total back pay could be 2, 3, 4 years, depending on how long it takes your case to be processed. Okay, so we're going to try to go another 10 minutes or so. I'm going to try to end this a little bit early just because I'm getting kind of tired and I've got to go take the dog for a walk, and then hit the sack, because it's like I said, it's been kind of a long day. We got to the baby gets up like at 6:30, 6:45. Then the dogs wake up and they start barking. So it's it's been kind of a long day, which I'm not complaining about, but I'm not a spring chicken anymore, as it were. Okay. Rich, just lost your SSD, making too much working part-time, filed an appeal, asked to waive the overpayments. I think that I would look at the months that you were overpaid. Is there any way to reduce the figure by reasonable expenses, money you had to spend to accommodate your medical issue, costs of doing business? Let's say you're a courier driver, you've got gasoline, insurance, tires, things like that. If you had to purchase a large monitor, rent something to allow you to work, I think those are the things, and then as far as going to a hearing and an overpayment, why was it not your fault? And again, that's a hard argument to make. So, I've tried a couple of those, and honestly, I'm not getting good results, because judges are like, you should have known, and again, even though the idea of knowing what the trial work period numbers are and the SGA numbers is not real intuitive, there's no real-time reporting, they seem to think you should know. So it's you can ask for a more reasonable overpayment, repayment plan. That would be something to do. But other than that, no, I don't know. Okay, Kelly, thank you very much. I appreciate that, and I will definitely get back to you. You need to sue them for discrimination. That's not going to go anywhere. If you got a class action, there've been a couple of those, but that's pretty rare. I mean, there's something called sovereign immunity. Everybody is unhappy with Social Security. Proving discrimination is going to be really, really hard. I don't want to tell you absolutely not, but really, really hard. Okay, so we're, yeah. Okay. All right. Okay. All right. So broke Dan's mom is talking about the ECT. Again, this is an individual decision. This is an individual decision. I obviously I'm not going to offer medical advice here. 5 conditions. Limited work experience driving for a living. My hearing so medical doctor about 32. So 32 is going to be one of the big issues there. Very limited work experience, striving for a living, hearing mental doctor, but I'm 32. Again, it's just going to come down to what the doctors say, how severe things are. If you get a good judge, you get a high approval judge versus a low approval judge, a lot of factors. Uphill battle, no question, no question. Okay. Okay, so Emily's, you're not going to convince Emily that ECT is a good idea. She's comparing it to one flew over the cuckoo's nest, which is not a good place to be, I would say. Although I will tell you, I have I wouldn't call him a friend, but an acquaintance, fellow that I've known for many years who happens to be a psychiatrist, and he's got a daughter who's the same age as my daughter, and they went to school. I think they went to school together. They played sports together, something like that. And so, and I know this guy, well enough I can call him up. And we were talking one time, just in a social setting, and I kind of casually mentioned that, I thought that ECT, I had a client, go through ECT, and I thought it was kind of barbaric. And he was like, absolutely not. He goes, it is a well-tested, well thought of, and very effective treatment for treatment-resistant depression. So, this is a psychiatrist. He doesn't do them. He doesn't make money out of them. But he felt, this is probably 10, 15 years ago we had the conversation, he felt it's a legitimate therapy. So, I don't know that I want somebody putting electrodes in my brain. But, if you're that desperate, again, I know ketamine is something that's been used. There's a stimulation type of thing they can do, stimulation. I don't remember what it was. I think you got to really do your due diligence, because treatment-resistant depression is debilitating, no question about it. I know they've been talking about using magic mushrooms or LSD for it. So there's the medical community is really flummoxed, I think. So anything that will give you back your life, I say you got to look at it. Will they automatically connect? I don't think they automatically do. I think with SSDI, they might automatically consider SSI, or I don't remember. I think that if you're not sure that you applied for SSI, go ahead and apply for it. Call them up and say, I want to add an SSI to my case, or the other way around. I wouldn't assume anything that they're going to do anything automatically. Okay. That would not be a case I could do. And as far as any suggestions, I just don't. I think that suing the Social Security Administration is, most people are not going to have the money to pay a lawyer to do it. You're not going to find anybody who's going to do it on contingency unless the problem is extremely egregious. Perhaps looking for somebody who sues the federal government, but I think it's just a real uphill battle. And unfortunately, I'm not discounting what you're telling me, but I just think it's, it's the deck is stacked against you. Chronic illness, again, it depends, Benaya, if I'm pronouncing that correctly. What are the symptoms? How does it affect you practically? Okay, risk of memory loss with the ECT. You're welcome, Naya, and I wish you the best. Okay, let me see if I got any more comments here. Or we are like it's pretty much the comments have ended. So, got one more. So no problem. Nice. So sorry for the rant. Not a rant. And I get it. And this can be a really unfair type of system. And so, I get it. Why, and who knows? There may be people there that, said things or did things they should not have done. Proving it is the problem, and proving that was your damages is the problem. That's when you're suing the government. That's the problem. Kenneth says, I filed one of my cases for disabled widows benefits. Told is fully favorable. Now the SSI cut down really low. Told me I won't receive any retro payments. That's a math issue. Disabled widow benefits is not SSI. It's SSDI. So the SSI probably got offset, but you're probably still going to get disability benefits under the disabled widows policy claim, because that's a disability program, not an SSI program. Now I've had this happen before. What they do is, let's say you apply for both, you're found not to be eligible for SSI, and then 5 days later you get a letter saying you're getting all this money for SSDI or widow's benefits. So you may be in the process of getting the letters. Where can you get represented? I would look at attorneys who do, federal court litigation against the government is how I would start my search. Okay, Emily. Well, good. I'm glad that you are tuning in. Thank you. Yes. Should you submit your new MRI to the? Absolutely. I'm going to zoom through these because we're going to be ending in a couple minutes here. Absolutely, want to send that would be a really good idea, Mrs. K. The work credits, service connected, make it aware I can't work due to disability. Yeah, without work credits, you're going to have a really hard time. It's not going to, you're not going to be able to pursue SSDI. If you're getting VA benefits, that'll offset the SSI. Okay, and again, I think you may have to talk to a number of different lawyers to find somebody who will do that kind of litigation. All right, thank you. Welcome. Okay, I'm going to go ahead and end this now. Like I said, it's 10:15 Eastern, and I've got to, like I said, I got to walk the dog, get to sleep, and get up early tomorrow morning. But we'll do it again next week. If you have any questions, send them to me ahead of time or let me know. Post some comments, and we'll do it again next week. I'll be back home in my normal, better lit studio with much better camera. So I know that technically this wasn't ideal as I'd like it to be, but I wanted to come on regardless. So I hope everybody has a great Thanksgiving tomorrow, and again, just stay healthy and be, hopefully with the ones that you care about. That's the most important thing about this time of year. So everybody take care. We'll see you next week. Bye-bye.